Good morning, everyone. This is the case of the people of the state of Colorado versus James Egan Holmes, case number 12 CR 1522. The record should reflect that Mr. Holmes is present with his attorneys, Ms. Brady, Mr. King, Ms. Nelson, Ms. Higgs, and Ms. Spengler. And the people are represented by Mr. Brockler, Mr. Orman, Ms. Pearson, Ms. Tish McGuire, and Mr. Edson. And we are outside the presence of the jury at this time. Are the parties ready for the jury?
Yes, sir. Sure.
Oh,
Your Honor, I have one matter that needs to be put on the record.
yes.
I want to let the court know, and I apologize for this, that, and I've spoken to Ms. Teach McGuire about it, but James's sister, Chris, has been in the courtroom yesterday. I did not advise her correctly. I thought that she was already excluded from the sequestration order. She was not, and that is my fault. That is not her fault. I apologize to the court, and I apologize to Ms. Teach McGuire. I did ask her if she had any opposition to excluding her from the sequestration order so she could be present. Ms. Teach McGuire indicated that she does not have any opposition to that, and I did let her know of my mistake yesterday, so I'd asked to modify that order.
Your Honor, if I could, I was just made aware of this by Ms. Teach McGuire. Can we have some time to think about this and take this part under advisement and discuss it at a break, possibly?
All right. If the people want to discuss it, that means that my previous order stands, so she would have to be excluded from the courtroom until I modify the order, if I modify it. I'm assuming that you're referring to, when you say James, you're referring to your client, Ms. Higgs, and when you say Chris, you're referring to Chris Holmes, your client's sister. Is that correct?
Yes, Your Honor, that is correct.
All right. At this time, she's not exempt from the sequestration order, so she'll have to wait outside, and then let's discuss it at the break. And then if the people have a change of mind at that point, then she can come back in the courtroom. Or even if the people don't have a change of mind, if you still want to make that request, I will consider it at that time, okay? So she should step out for now. All right, let's bring the jury in, please. Oh, sorry.
I just wanted to make the page from the DSM that Mr. King used in his cross-examination with Dr. Metzner yesterday. I would like to mark it as a court exhibit, if that's okay with the court, just out of an abundance of caution.
Of course.
So I think we're up to CTR 51.
Yes.
Is that right? Okay, and I'll provide it to your staff at the break.
Great, thank you. And that was the page that Mr. King used with Dr. Metzner during his cross-examination yesterday, and it's a page out of the DSM-5. Okay, let's bring the jury in, please.
Our number DTR 57, just for the record.
Great, thank you. Apparently one of the jurors is still not here, so let's have everybody be seated. I could have kept everyone standing, but I figure you could be more comfortable. Mr. Brockler.
Unless the court has other business, I could address the issue with the sister thing right now and just have a quick conversation if the court's amenable to that?
Of course.
Your Honor?
Yes, sir.
Hey, I've talked about it with the smarter people at my table, and I think the position that Ms. Tish McGuire conveyed to Ms. Higgs is the one that we're in agreement with and would adopt. So we have no objection to the court amending its order about sequestration to permit the defendant's sister to be present in the courtroom.
Okay, without objection, then I will grant the request. So the sequestration order is orally amended, and Chris Holmes may be present in the courtroom even when she's not testifying, and specifically before she testifies.
Thank you, Your Honor.
Okay.
Your Honor, if I may. I don't know if this is a good time to discuss the email situation, since we seem to have a little bit of time.
I'm trying to find out what's going on with the juror who's missing, so as soon as I have some information, I'll let you know. I don't want to get started and then find out that she's here, so. I'm going to step down and try to find out if there is an update on the missing juror, and then as soon as I have an update, we'll let you know. Okay, the court will be in recess. Thank you. Holmes is present with his attorney, and Mr. Proctor, Ms. Pearson, and Ms. Tish McGuire are present. We are outside the presence of the jury. The juror who's missing left a message early this morning for us, or not that early, but indicated that apparently there was a power outage in her home and she overslept. The alarm didn't go off, and so she called at about 8:15, it sounded like, and said she was on her way, but she's not here yet. And I'm not sure whether we misunderstood in terms of the time. We think she called at about 8:15 and said she was on her way, but that may not necessarily be accurate. And so, given that, I think we'll make use of our time, and I'll rule on Exhibit P-TR-1227. And Dr. Metzner, you can stay there or you can step down, whatever's most comfortable for you while I do this, okay? Yes.
Judge, could we inquire what the juror number is?
Yeah, this is juror number 640, who's never been late before. So, the juror who was late yesterday was a different juror. I believe that was 872, who was running a little late yesterday. And then these are the only 2 days that we've had anyone be late. Other than yesterday and today, the jurors, all 24 of them, have been on time every time. So, all right. There are some global objections to Exhibit P-TR-1227. And there are some specific objections to 12 particular emails. In terms of the global objections, there's a relevance objection, there's a Rule 403 objection, and I'm going to address those in a little bit. There's a hearsay objection, so let me address that objection first. In terms of the hearsay objection, the objection is overruled. To the extent that the emails in this exhibit contain statements by the defendant, those statements are not hearsay, they are statements by a party opponent. To the extent that the emails contain statements by someone else, they're not hearsay because they're not being introduced for the truth of the matter asserted. They're being introduced to place the defendant's statements in context so that the jury can understand the defendant's statements in context. And I'm happy to give a limiting instruction along those lines. I'm making the same offer that I have made throughout the trial to the defense in terms of giving the jury a limiting instruction with respect to these statements made by people other than the defendant. I disagree that a limiting instruction will not be adequate in this case, and there's no basis that supports that argument. This happens all the time in courts. Statements are admitted that are not hearsay, and if a party wants the court to tell the jury specifically that those statements are being admitted, for example, to show the effect on the listener, or, for example, to place in context some other statements, courts do that. This happens all the time. So I disagree that a limiting instruction will not be adequate to address this particular situation, especially given the nature of the statements by other folks in these emails. These are not statements that, in general, have any risk of undue prejudice or that lead me to conclude that one or more of the concerns listed in Rule 403 is present, or that one or more of those concerns should lead me to keep these emails out. Number 5 is a confrontation issue. There's not a confrontation issue here. These are not hearsay statements. These are statements by the defendant, which constitute statements by a party opponent, and statements by other people that are not being introduced for the truth of the matter asserted. But in any event, to the extent that the defense wants to examine these folks, they're welcome to do it. And to the extent that these folks have already testified, if the defense wants an opportunity to call them again, I'll give them that opportunity. Same thing with people who haven't testified, or perhaps people that the defense is not familiar with. I think Ms. Spengler named one person that she said they weren't familiar with. I think it was somebody by the last name of Muck, M-A-U-C-K. And if the defense wants an opportunity to call that person to the stand and other people to the stand, whether they've been called before or not, I'll give them a chance to do that. They'll have an opportunity to do that. There was a reference to character evidence, and I think Ms. Spengler was trying to be candid with the court, and she put it up front with the court. And in that process, although she didn't concede that these were not character evidence, she acknowledged that the phrases in the specific objections don't necessarily fall directly within inadmissible character evidence. And I don't believe that any of this is character evidence. In terms of the relevance objection, that is the primary objection by the defense, and also related to that, the Rule 403 objection. And with respect to Rule 403, there seem to be 3 particular issues that the defense is focusing on. Danger of unfair prejudice, confusion of the issues, and related to that, inviting the jury to speculate. And then third is the unnecessary presentation of cumulative evidence. And so let me address the relevance and the Rule 403 objections. Global objection, I should say. These emails in this exhibit start on August 5, 2011, and they go through June 13 of 2012. So they span a period of less than a year, about 10 months. But this is most of the period during which the defendant was a student at the University of Colorado. And consistent with previous rulings, I find that these emails are relevant to the issue of sanity and to the culpable mental state elements of the offenses charged. These emails are probative of the defendant's state of mind, his ability to understand events and information and to respond to events, information, and queries in a logical and coherent fashion, his ability to be aware of and understand the world around him, his thought processes, how he was able to think and the way he was able to think, whether he had organized or disorganized thinking, the way he was able to perceive and process specific information, the way he interacted with other people and communicated with other people, the way he was able to share information with people as part of those communications, the way he chose words, and whether his speech or whether his communications, written speech it would be, or communications were organized or disorganized, whether he was connected or attached or detached or disconnected from reality, connected or attached to reality or disconnected or detached from reality, the way he was able to accumulate and put together information, all those things. And in sum, they're relevant to the defendant's mental state, mental processes, mental and cognitive capacity, and the issues related to the plea of not guilty by reason of insanity and the culpable mental state elements of the offenses charged. It is worth noting, as I have done before, that there is a disagreement between the parties in this case as to whether the defendant's mental state and mental capacity experienced some type of decline in 2012. As I have understood the parties, the defense appears to assert that the defendant's mental state and mental capacity deteriorated in 2012, perhaps as early as February when he first sought counseling, or even in March. The prosecution appears to allege that nothing changed and that the defendant was the same throughout 2012 as he was before. This disagreement is one of the issues, or is at the heart of the issues raised by the insanity defense. And not surprisingly, both sides have spent a lot of time on the issue as they question witnesses. In order for the jury to assess each party's position, I think the jury needs to have a frame of reference. The jury needs to have something to which to compare the defendant as he was in the first part of 2012 or throughout 2012. During the first 4 or 5 months of 2012, the main aspect of the defendant's life and the aspect that consumed most of his time was school. Therefore, it is important, in my view, to allow the jury to view information about the defendant as he was in the last half of 2011 when he started school, or around the time that he started school. So that way the jury can compare the defendant as he was when he was in school in 2011 and as he was when he was in school in 2012. After all, school was the main part of his life during that time frame. Consistent with this view, I have allowed emails throughout dating back to 2011, and I think essentially to April, May, or mid-2011, whenever the defendant started school or whenever he started communicating about school, and whether it was registration or getting an apartment or classes, the program, all those things. All of the emails go back to, I think, April or May, perhaps June of 2011, and they're related to the defendant's school life. The emails in question will allow the jury, and when I say the emails in question, I'm referring to the ones in P-TR-1227, will assist the jury as the jury considers the defendant's mental state and mental capacity in this continuum or progression of time between 2011 and 2012. And it's really between the summer or fall of 2011, mostly the fall, and then the spring and summer of 2012. And it's really mostly the spring and then the beginning of summer of 2012. Dr. Reed, by the way, opined, as I understood the testimony, that the defendant had negative symptoms of schizotypal disorder going back to high school, and that he started experiencing symptoms of delusional disorder sometime in 2012. The range of dates of all these emails in Exhibit 1227, P-TR-1227, is certainly within one of those time frames. and the range of dates of most of the emails in this exhibit is within both timeframes. Dr. Metzner, who's still testifying, I think said yesterday that the defendant experienced some negative symptoms, what has been referred to as negative symptoms, as far back perhaps as undergraduate school. I think he said in college. Additionally, Dr. Reed testified that in assessing the defendant's sanity, it is important to explore all aspects of his life. He certainly did that in his lengthy examination. Dr. Metzner, as far as I can tell, did the same thing. Dr. Metzner performed a lengthy examination of the defendant over 25 hours and explored multiple areas of the defendant's life and went back before July of 2012, in fact, long before 2012. And by the way, I don't know that I agree with the defense when the defense asserts that these experts did not rely on any of these emails. It's my understanding that these experts and other experts were asked by the parties to review most, if not all, of the discovery in this case. A voluminous amount of information, to be sure. I think Dr. Reed said last week that it was in the range of 60,000 or 70,000 pages, perhaps more. And in any event, the fact that an expert may not have specifically mentioned an email or emails in his report or testimony doesn't mean that they don't constitute a part of the information on which he relied in forming his opinions. For example, Drs. Reed and Metzner appear to me to have relied on the defendant's interactions with others, his communications with others, his behaviors, the organization of his speech and thinking, his mental processes and his mental capacity, and how any of that may have changed in 2012 as compared to 2011 and before. And these emails would be examples of some of those things. In any case, I agree with what Mr. Orman said last week when he argued about this exhibit, and he said that ultimately it is the jury that will make the decision on the issue of sanity, not Dr. Reed or Dr. Metzner or any other experts. So even if the experts had not relied on these exhibits or on these emails, it doesn't mean that they are irrelevant. They're not rendered irrelevant just because of that. But as I said, I believe that they have relied on some of these communications. They have relied on all the information that they have been provided, and certainly it's my understanding that they've been provided emails that the defendant was sending and have specifically looked at the things that I've talked about, the defendant's communications with others, interactions with others, the defendant's behaviors, organization of speech and thinking, the defendant's mental processes and the defendant's mental capacity and cognitive abilities, and how they may have changed between 2011 and 2012. Let me just say, by the way, that I understand that just because you're able to interact with others, to communicate with others, to process information, to respond to information logically, reasonably, coherently, and appropriately, etc., I get it. I get that that all does not necessarily mean that you're sane. I get that. And that's a point the defense has been making throughout. But that also doesn't mean that any evidence of your cognitive capacity to interact with other people, to communicate with them, to process information, and to respond to information coherently, logically, reasonably, and appropriately, etc. And when I say etc., I'm referring to the other things that I have mentioned, the other activities that these emails deal with or are probative of, or the other aspects of the defendant that the defendant's mental state that these emails are probative of. It doesn't mean that they have no relevance to the issue of sanity. So yes, on the one hand, just because someone can communicate and interact with people and process information, it doesn't mean that they're sane, but that also doesn't mean that the person's communications and interactions and evidence of his ability to process information and to respond to it appropriately and coherently is inadmissible, or that it is irrelevant. And I think that the testimony of the two court-appointed experts, Drs. Reed and Metzner, show my point, or I think they corroborate the point that I just made. But as I said, the relevance of this exhibit exist independent of their opinions. So for all those reasons, I find that these emails are relevant. I also find that the probative value of these emails is not substantially outweighed by the danger of unfair prejudice or by the danger of confusing the jury or inviting the jury to speculate or by the unnecessary presentation of cumulative evidence. In terms of the specific objections, let me run through the 12 emails or email exchanges that were identified by Ms. Spengler. The first one is email August 23, 2011, number 1359, and the number refers to the bait stamp number. This is an email exchange between the defendant and his father, Robert Holmes. And then I think there was an argument that there is double hearsay because Mr. Holmes, Robert Holmes that is, discusses statements by Chris Holmes, the defendant's sister. It's not hearsay and it's not double hearsay because these statements are not being admitted for the truth of the matter asserted. In terms of character evidence related to Chris Holmes, I don't find that to be character evidence. Again, it is not being introduced for the truth of the matter asserted, and I don't think it rises to the level of character evidence. It is a statement, I think, that Robert Holmes is conveying to his son about something that Chris said to him about her roommate in college, and her roommate possibly being a crip, C-R-I-P. And the defendant in response to that, finding it unlikely that that's true or that that's the case. And so it's probative because, for all the reasons I stated earlier, but it is also probative specifically because it shows the defendant's ability to understand and process the information and events discussed by his father. It also demonstrates his mental or cognitive capacity to respond to his father in a logical, coherent, reasonable, and appropriate fashion, and it is within the time frame that we've been working, or that I've been working with. It's August 23, 2011. It's certainly within the time frame that the experts have found to be relevant. So the court concludes that this evidence is probative of the issues of sanity and the culpable mental state elements of the crimes charged, and the probative value of the evidence is not substantially outweighed by any of the dangers listed in Rule 403. Again, this is an exhibit. This is the earliest, one of the earliest emails in the exhibit. It's from August 23 of 2011. And by the way, most of the emails are from 2012, but this is one of the earlier ones. But I think in addition to what I just said, it also gives the jury a reference point, a point of reference to compare the defendant in 2012 to. What was the defendant like before 2012, and was there any change? Was there anything that changed? Was there anything that changed in terms of his mental capacity that shows that he developed a mental illness, or that perhaps even if he had had a mental illness already, that somehow it became more, it was manifested more clearly? I think the jury, in order to assess those types of issues, needs to have a point of reference, needs to be able to compare that to something before that. Number two is the email from October 30, 2011, bait stamp number 2964. This is an email exchange between the defendant and his mother, which contains a reference to speeding and the police being lame. And Ms. Spengler, again, I think in an effort to be as candid as possible with the court, acknowledged that this is probably not inadmissible character evidence under Rule 404. She didn't concede it, but she said it's probably not inadmissible character evidence. And I appreciate her candor, and I agree with her. I don't think this is inadmissible character evidence or that it falls under Rule 404 either. As to the irrelevant and Rule 403 objections, it appears to me that the primary concern here by the defense is for the risk of unfair prejudice. I see very little, if any, risk of unfair prejudice here. I mean, a speeding ticket in the context of this case is extremely unlikely to have any risk to prejudice the defendant in any unfair way, or in any way for that matter. The same is true for the defendant's comment about the cops in Colorado being lame for not even having a 15-mile-per-hour leeway, as he put it. A lot of people get a speeding ticket at some point in their life, and when it happens, it is not uncommon for people to feel annoyed at the police for having received a ticket, and it's not uncommon for people to have the type of reaction the defendant had, especially given that it was, he felt that this was a speeding ticket for going, I think, 11 miles over the speed limit. Also, the most reasonable inference that can be drawn from a subsequent email from November 15, a subsequent email exchange about 2 weeks later between the defendant and his mother, which is at Bates stamp number 3297, is that this was the defendant's first speeding ticket. The defendant's mother asks the defendant if there is a way to do online traffic school to knock off the speeding ticket. The reaction was not, oh well, another speeding ticket, you know what to do, or just pay it off, you've done it in the past, that kind of thing. The reaction seems to me to suggest that this is not a common occurrence with the defendant. On the probative side, in addition to the reasons that I have stated earlier, the email from the defendant in this exchange contains a discussion about activities that he is engaging in with his gal, as he refers to her, and with his friends. One of the big themes in this trial has had to do with the defendant's ability or inability to socialize with others in 2012, including how shy and introverted and socially awkward he was at that time. The parties appear to disagree about whether these are symptomatic of mental illness or whether they are merely normal traits of the defendant's personality, and whether there was a change in these behaviors at some point in 2012. The defendant's discussion of social activities with his girlfriend and friends in late 2011 goes to these issues. As such, this is evidence that is probative of the issues of sanity and the culpable mental state elements of the crimes charged, and the probative value of the evidence is not substantially outweighed by any of the dangers listed in Rule 403. Having said all of that, in an abundance of caution, if the defense wishes, I will order the prosecution to redact this particular page of the exhibit by deleting the following words. And then I got a speeding ticket because the police are lame here. 46 in a 35 zone, not even a 15 mph leeway. In my view, such a redaction will not take away the primary probative value of the email, but will completely avoid any danger of unfair prejudice. So I'll leave it to the defense to tell me whether they prefer to have that redaction made or whether they would rather not have the redaction made. Either way, the defense is not waiving their objection. I understand their objection. I'm overruling it. I'm giving them a choice of whether they wish to have that redacted or not, and it is up to them to make that determination. Number 3 is an email from November 15, 2011, Bates stamp number 3297. I just mentioned this a moment ago. This is an email exchange between the defendant and his mother. This is the one that contains a reference to the speeding ticket and whether it can be knocked off through online traffic school. The defendant responds that the amount of the fine is not yet showing online. The defense makes the same objections to this email as it made to the last email, so it's the same ruling. In this email exchange, by the way, on the probative side, the defendant mentions that he plans to spend Thanksgiving with a bunch of his peeps, which I infer to mean his friends, and with his gal, Gargi, which he says should be fun. For all the reasons I have mentioned previously, including in the ruling on the admissibility of the last email from October 30, 2011, this email exchange, in my view, is probative of the issues of sanity and the culpable mental state elements of the crimes charged, and the probative value of the evidence is not substantially outweighed by any of the dangers listed in Rule 403. Consistent with my last ruling, if the defense will, or excuse me, Mrs. Holmes's comment, no response to my email about your speeding ticket. Can you knock it off your record by online traffic school? to understand the world around him, to process information, to react appropriately, logically, reasonably, and coherently to it. But as I said, I will still order those redactions if the defense wants them, because in my view, such redactions will not take away the primary probative value of the email, but will completely avoid any danger of unfair prejudice with respect to the speeding ticket. And the same thing is true with the last email. Next is number 4, an email from December 9, 2011, bait stamp number 3987. This is an email by Cami Kennedy, a program administrator at the University of Colorado, asking about the defendant's correct date of birth. The defendant responds with his correct date of birth. And if I remember correctly, I think she had 2 possible dates of birth and was trying to figure out which one was the right one. Ms. Spengler said, seemingly, I suppose, this is insignificant, but there's no relevance, and why draw the juror's attention to the fact that the university may have had 2 dates of birth to the defendant? I agree that this is insignificant in terms of any unfair prejudice or any risk for unfair prejudice. In terms of the probative value, the court relies on all the reasons I have previously articulated. Specifically, as it relates to this email exchange, I note that the defendant responds to a query by the school. He processes the information and replies with the information requested in an appropriate, reasonable, logical, and coherent format, which again goes to his state of mind and his mental processes, and by extension to the issues of sanity and the culpable mental state elements of the offenses charged. And in my view, the probative value of the evidence is not substantially outweighed by any of the dangers listed in Rule 403. Next is the January 16, 2012 email, bait stamp numbers 4456 through 4459. This is an email exchange between one of the defendant's professors, Diego Restrepo, R-E-S-T-R-E-P-O. All the email from Professor Restrepo says is that he marked up a document apparently submitted to him by the defendant using that's a small I, annotate, A-N-N-O-T-A-T-E, on the professor's iPad. There appears to be an attachment to the email with the defendant's submission, and there are 3 handwritten markings or notes by the professor on that submission. The last page, page 4459, bait stamp, page 4459, has the defendant's response to the professor's constructive criticism. And the defendant's cognitive ability to understand and react to constructive criticism, his thought processes, the way he processed information, the way he put information together, all of which is relevant to the issues of sanity and the culpable mental state elements of the offenses charged. And the probative value of the evidence is not substantially outweighed by any of the dangers listed in Rule 403. Next, I have an email dated January 31, 2012, bait stamp number 5334. This is an email by the defendant to Frank Guido, G-U-I-D-O. I think Frank Guido is a professor at the University of Colorado, and the defendant is inquiring about a 3rd rotation. There's a reference in the email to the work being done by Mr. Guido, or Professor Guido, on impulsive aggression disorder.
Your Honor, just so the record's clear,
Yeah.
I think it's actually Guido Frank. I think the last name is first.
Okay, thank you. Guido Frank, thank you for that correction. And so I believe that the particular concern the defendant has is the potential for and the only difference that I can see, substantive difference that I can see between the emails is the subject of the lab work being done. I'm not concerned because it is clear to me, and I think it'll be clear to the jury, that the email does not demonstrate the defendant's interest in impulsive aggression disorder. Rather, when the email is viewed in the context of the other 3 emails, the other 3 similar emails, it is clear to me that the defendant is simply trying to be allowed into a 3rd rotation. That's consistent, by the way, with the evidence that the jury has heard so far. Additionally, there has been no mention in this case of impulsive aggression disorder as something that the defendant was concerned with in his self-diagnosis. nor has there been any reference to this disorder by any expert, and there's no evidence that this disorder was present in the defendant at any time, or that the defendant's alleged conduct at any time was consistent with this disorder. So in the end, I don't see much, if any, risk for unfair prejudice, and this email has probative value for all the reasons that I have said before, including with respect to the defendant's state of mind, ability to process information, the issues of sanity and the culpable mental state elements of the offenses charged, and the probative value of the evidence is not substantially outweighed by any of the dangers listed in Rule 403. Nevertheless, having said all that, if the defense wishes, in an abundance of caution, I will order the people to redact those 3 words from the email: impulsive aggression disorder. Such a redaction, in my view, will not take away the primary probative value of the email, but will completely avoid any danger of unfair prejudice. Number 7, this is an email exchange. Actually, this includes 2 emails. From February 7, 2012, it's an email exchange at bait stamps numbers 5623 through 5626, and then an email exchange from February 15, 2012, bait stamp numbers 5781 to 5785. All of this is generally an email exchange and a continuation of that email exchange between the defendant and Professor Kurt Freed, who has testified. Ms. Spengler admitted that the context of these emails is generally benign. I think she meant the content of the email is generally benign, and I may have written down the note incorrectly, but the content of the email is generally benign, and I agree with her. It's simply about scheduling. However, there are references to doing rat transplants, and I think that's her concern under Rule 403 and under Rules 401 and 402. I don't see any risk of unfair prejudice or any risk of prejudice in general at all. I have said this before, and I'll say it again. I don't see the reference to doing research with rats as having any risk at all of undue prejudice or any risk at all of any prejudice. And this email exchange, in my view, is probative of all the issues that I have articulated before throughout my ruling today, and it is therefore relevant to the issues of sanity and the culpable mental state elements of the offenses charged. And the probative value of the evidence is not substantially outweighed by any of the dangers listed in Rule 403. Next is an email exchange from February 13, 2012, bait stamp number 5747. This is an email exchange between Cami Kennedy, the program administrator at the University of Colorado that I mentioned earlier, and the defendant. But the email from Ms. Kennedy is specifically sent to a bunch of students or multiple students, including the defendant. And then there's an attachment to the email, which is a summary report purportedly written by the defendant to the National Institutes of Health. And I believe there is a response by the defendant attaching that summary. The summary references in vitro experiments on rat brains. And I believe that it's the reference to these experiments on rat brains that the defense finds particularly problematic under Rules 401, 402, and 403. For the reasons I stated, I disagree. I don't see anything concerning with respect to research with rat brains. And in my view, the attachment appears to be something the defendant wrote about a very complicated scientific concept in February of 2012, so just some months before the shooting. And in my view, it is relevant for all the reasons that I have articulated throughout my ruling today, including because I think it is probative of his state of mind, ability to process information, mental and cognitive capacity, and by extension, the issues of sanity and the culpable mental state elements of the offenses charged. And the probative value of the evidence is not substantially outweighed by any of the dangers listed in Rule 403. Number 9 is an email exchange from February 19, 2012, bait stamp number 5919. This is a short email exchange between the defendant and Cami Kennedy, the program administrator at CU, regarding an issue with the defendant's billing statement. Ms. Spengler argued that this has very limited relevance and that it's inflammatory because it shows that the state of Colorado was paying for the defendant's tuition. I'm not sure what's inflammatory about that. I disagree. I don't see anything inflammatory from the fact that the school had apparently given the defendant some kind of scholarship or funds to pay for his schooling. And in my view, the probative value, actually, let me back up. She argued also that the probative value does not outweigh any of the potential inflammatory effect. And that's not the standard. She may have misspoken, but the standard is not whether the probative value outweighs any potential inflammatory effect. The standard under Rule 403 is whether the probative value is substantially outweighed by the risk for unfair prejudice. So in this case, the email exchange contains a reference to the defendant discussing financial issues related to his education. So it is probative of all the issues that I have articulated earlier, including of his state of mind, ability to understand the world around him and to respond to questions and appropriately. And it is also probative of his attachment to reality, or whether he was attached or detached. He was attached to reality or detached from reality. So I find that it is relevant to the issues of sanity and the culpable mental state elements of the offenses charged, and the probative value of the evidence is not substantially outweighed by any of the dangers listed in Rule 403. Next, we have an email exchange from February 23, 2012, base stamp number 6101. This is an email regarding a different exchange between the defendant and Dr. Freed, again about scheduling. This one references work that the lab is doing with rat brains, and that is the concern that was expressed by Ms. Spengler, the mention of work with rat brains. I'll just say again, I disagree that there is anything at all that causes me concern about that. I don't see that as having any risk at all of undue prejudice or even prejudice at all. So, and as I mentioned earlier, this exchange is relevant for the reasons that I have been articulating throughout my ruling. So I find that it is relevant to the issues of sanity and the culpable mental state elements of the offenses charged, and I find that the probative value of the evidence is not substantially outweighed by any of the dangers listed in Rule 403. The penultimate email exchange in this exhibit is an email exchange dated March 26, 2012, bait stamp number 6859. This is an email exchange between the defendant and a Mary Muck, M-A-U-C-K. I mentioned her name earlier. In this email exchange, the defendant is requesting after hours and weekend batch access to the lab. As I mentioned before, Ms. Spengler said that defense counsel are not familiar with Ms. Muck, and none of the experts have relied on this email or on her. And that doesn't render this email exchange irrelevant or inadmissible under Rule 403. As I mentioned, counsel can call Mary Mott to the stand if they wish. I will give them an opportunity to do that. And this email is relevant for all the reasons I have been articulating throughout my ruling. And so I find that it is relevant to the issues of sanity and the culpable mental state elements of the offenses charged. And I find that the probative value of the evidence is not substantially outweighed by any of the dangers listed in Rule 403. Finally, there is an email exchange dated May 16, 2012, bait stamp number 8587. This is an email exchange involving the defendant and Professor Freed and Lee Young Mook, M-O-O-K. The defendant forwards his rotation PowerPoint presentation in this email exchange, or at least a draft of it, and it is unclear whether it is a draft or the final version of the PowerPoint presentation. Ms. Spengler argued that the jury has already seen a portion of the presentation on video, and that Dr. Freed has already testified, and also that we do not know if this is the final draft of the presentation. In terms of Dr. Freed already testifying, I will, as I said, give the defense an opportunity to call him again if they wish. In terms of the jury having seen a portion of this presentation on video, Ms. Spengler is right. The jury saw 3 short clips, video clips, of the final presentation that the defendant made. They were very short. I think they were 1 minute to 2 minutes each in length. And Ms. Spengler is also right that we don't know if this is the final draft of the presentation or if this is a draft before that preceded the final draft. But I nevertheless find that this email exchange, including the attachment, is relevant because what we can reasonably infer from it is that this is something the defendant put together around May of 2012. It is something he wrote in May of 2012, which is only approximately 2 months before the shooting. This presentation goes to the defendant's ability to put together information in a manner that does not appear to be, in a manner that arguably does not appear to be disconnected from reality, that appears to be coherent, that appears to be logical. Of course, the jury will have to assess that, but it is relevant for those reasons. And this is within the time frame that Dr. Metzner testified the defendant had already had, I think, a trigger present in March in the Gmail chat. So this would be after that Gmail chat between the defendant and his girlfriend. And so it's within the time frame that's shortly before the shooting. It is generally relevant to the issues of sanity and the culpable mental state elements of the offenses charged. And in my view, the probative value of the evidence is not substantially outweighed by any of the dangers listed in Rule 403. I want to be clear again. My rulings should not be confused with saying and should not be interpreted as saying that these emails show that the defendant was sane at the time of the offenses charged. My ruling simply is that they are probative of the issues raised by the defense of insanity, and they are probative of the culpable mental state elements required by the offenses charged. My ruling is that they are relevant, that they have some relevance to those issues, and that the probative value of the exhibit is not substantially outweighed by any of the dangers listed in Rule 403. So the defense can let me know whenever, if it wishes to make the redactions that I have offered, or whether it prefers not to make those redactions. But for all those reasons, the exhibit is admitted. All right, I need to step down for a moment, so I'm going to step down for a few minutes, and then I'll take the bench again, and then we'll hopefully start with the jury at that time. The court will be in recess. Thank you.